The views and opinions expressed in this podcast are simply that, opinions. All are presumed innocent until proven otherwise in a court of law. Sensitive topics are discussed. Discretion is advised.
I'm Vinnie Politan. The subject of my investigation is the Menendez brothers. It was the first huge trial on court TV, and now 30 years later, the convicted double murderers who escaped the death penalty are looking to get out on parole. Here's the story. On the night of August 20th, 1989, the Beverly Hills mansion of Jose and Kitty Menendez became the scene of unimaginable horror. Lyle and Eric Menendez, their sons, fired shot after shot, brutal, merciless, leaving their parents unrecognizable. The crime shocked the nation. Two privileged young men drowning in wealth turned savage killers. At trial, they claimed they weren't monsters, but victims, that their father was a tyrant and their childhood was a nightmare of abuse. The juries were split. Was it cold-blooded murder or a desperate act of survival? The second trial answered that question. 2 life sentences, no parole for the Menendez brothers. Now, decades later, they are fighting for their freedom, armed with new alleged evidence of abuse and support from advocates who see them as survivors, not as killers. Social media campaigns demanding their release. Will they ever walk free, or will the world remember them only for the night they murdered their parents in cold blood and covered it up? The case continues. It's amazing that I'm here at Court TV this year, 2025, and we're still talking about the Menendez brothers. But we are, because it's really happening. They have a potential opportunity here. It's a resentencing is what's happening. It's where you go before a judge, and a judge makes a determination about whether or not you should be resentenced. Now, for them, resentencing means the opportunity for parole, because they were sentenced to life without parole. So they want to change that to life with parole, and based upon the time that they have served, would make them eligible for that parole. So this motion was originally brought by a DA who is no longer in office. And there's a new DA in town. His name is Nathan Hochman. And he has a much different view of the Menendez brothers and the resentencing. Remember, his predecessor brought this, and his predecessor was supporting the resentencing of the Menendez brothers. Take a listen to the new DA, Nathan Hochman.
We are prepared to go forward with the court's initiated resentencing proceedings and look forward to a resentencing hearing on that motion. However, we are asking the court to withdraw the previous district attorney's motion for resentencing because we believe there are legitimate reasons and the interest of justice justifies that withdrawal. Now, when one deals with resentencing, one of the key hallmarks of resentencing is, do the defendants pose an unreasonable risk of danger to the community? One way to decide if they pose that risk is to understand if they have been rehabilitated. And one way to understand if they've been rehabilitated is, have they accepted and exhibited full insight into the crimes that they have committed and accepted complete responsibility for their criminal actions.
Not supporting it, okay? This is like a 180 in the perception of the case by the new DA, which brings us to the first question in our investigation. Not supporting it, is there anything that could change the district attorney's mind? Is there something, a piece of evidence or a statement or testimony or something, an argument that could change the district attorney's mind about his stance on whether or not to support the resentencing of the Menendez brothers? Well, there's only one way to answer this question. And joining us, the Los Angeles County District Attorney Nathan Hochman, joining us right now. thank you so much for joining us. Great to have you here. So it's a simple question. I don't think the answer is so simple, but is there anything that could change your mind and make you rethink the future for the Menendez brothers and support their resentencing and possibility of getting parole?
So, Vinnie, thank you very much for having me on. And here's the answer. And you have to understand where resentencing fits amongst the three different tracks that the Menendez case is currently on. The first track is actually a habeas track. This is a motion that they filed in May of 2023, asking for a new trial based on two new pieces of evidence. We submitted an 85-page position to the court analyzing those new pieces of evidence against the legal standard and showing that they did not meet the legal standard to justify a new trial. The second track is a direct clemency petition to the governor of California, Gavin Newsom. Gavin Newsom has a unilateral constitutional power for any reason he decides to commute the Menendez sentences and release them today, tomorrow, or for that matter, any day he's been in office since 2019. Or he can do nothing. The third track is this resentencing. Again, it's a somewhat unique California idea or law that was passed. It said not only are we going to look at the crime that people committed, but we're also going to look at other factors, including rehabilitation. However, the standard is, do the defendants pose an unreasonable risk of danger to society after you do this entire analysis? And Governor Newsom gave us insight into what a full and complete rehabilitation looks like when he denied the parole for Sirhan Sirhan, the assassin of Senator Robert F. Kennedy back in 1968 in Los Angeles, someone who'd been in prison for over 50 years, who's 77 years old and in diminishing health, who was 24 when he committed the crime, and has been in successful rehabilitation programs in prison. In fact, he scores out as the lowest risk score. Yet the governor denied Sirhan Sirhan parole when he said that over the time, he did not exhibit full insight into his actions. So we have taken a similar stance. And when you ask, is there a pathway for the Menendezes, at least as far as the district attorney's office, to recommend resentencing, we actually set that pathway out. We identified 20 lies that they have told, and the primary lies is the first lie of self-defense. They said, in essence, that they shot their parents, shotgunned them to death with 12 different shotgun blasts, staged to look like a mafia hit, including a shotgun blast to the back of their father's head. They shotgun blasted their mother while she lay dying on the floor by reloading their shotgun and putting the gun up to her face and pulling the trigger. They then shotgunned each one of their kneecaps after they were dead to make it look like a mafia hit. What we said is that self-defense, that they said that they did it because they thought their parents was going to shoot them that night, and they did it preemptively, was a complete fabrication. And we analyzed that, again, with over 85 pages of factual and legal argument to show why we believed it was a fabrication. They also suborned perjury from their friends, where they basically said they wanted their friends to say their dad was a violent rapist, that they had gotten a handgun the day before the shootings, which they never got, and that their mother had tried to poison them, which never happened. So we're basically saying, if the Menendez brothers fully and completely, unequivocally and sincerely admit and come clean that they have lied about the self-defense, that they have lied about suborning perjury and attempting to suborn perjury for over 30 years, and finally exhibit the full insights into their criminal conduct, that at that point, we will reconsider whether or not at least the DA's office goes forward on a resentencing and recommends it.
Let me ask you, how does that happen? What form does it take? Would it be in court, under oath, on a witness stand, and you or folks from your office question them and they answer questions? Is it an affidavit? What form would it take for you to change your mind that, hey, they are finally taking responsibility here? How would that work?
So we're open to any suggestion that the Menendez brothers' attorneys have as to how they want to demonstrate an unequivocal and sincere, effectively, admission that they've been lying for over 30 years on this self-defense defense and suborning perjury during their trial. If they want to do it by way of sworn affidavit, if they want to do it by way of sworn testimony, again, the point is to see if they finally can come clean and then do it sincerely and unequivocally. And ultimately, it's not the district attorney that makes that call. It'll be the judge that hears it.
And from your perspective, how do you determine sincerity?
And, you know, again, if they equivocate, if they say, well, maybe, perhaps, it could have been, that doesn't indicate sincerity. That indicates that they're still trying to tell half the story, admit half the lie. If they fully and completely say, here's why we lied, here's exactly what we did to lie, here's why we continue to lie over the past 30 years, you know, again, that starts to approach the unequivocal and sincere nature that we're looking for as far as an admission that they have lied over the past 30 years.
And have there been any discussions since you've made your position public? Has anyone from their defense team approached you about perhaps trying to make that happen to satisfy what you need to support this resentencing?
They have not. The only thing that the defense team has done is go on TV programs to malign the district attorney's office, call us names. And we've basically responded, let's meet in court, let's line up the facts, let's line up the law. That's where our discussion will be held.
And if they did make all these admissions, right, and took full responsibility and came clean in all this, on one hand, right, you look at that on the one hand and it makes them look like, okay, they finally, you know, come to terms with everything. But on the other hand, it makes what they did, the underlying crime, even more evil. Do you see it as from both those perspectives, or do you see it only as a positive for them to make all those concessions and admissions of lies?
Well, as far as the evilness of this crime, the jury already made that decision back in 1995 when it heard this self-defense defense, when it heard about the Menendezes trying to suborn perjury and lies from their girlfriends and friends, and they categorically rejected that self-defense when they found them guilty of first-degree murder with special circumstances, and ultimately they got sentenced to life without the possibility of parole. So the evilness is already established by their actions. Now, whether or not they've ever rehabilitated from those actions will be determined in large part on whether or not they finally completely and unequivocally accept responsibility for the full breadth of the lies they have been telling. So if they do that, and they can do it not just, again, to convince the district attorney's office, but to convince the court that will make the decision in the resentencing, then that court will most likely make that resentencing decision in their favor. If they don't do it, then I believe using that precedent of Sirhan, the court should not actually grant resentencing at this point.
And in terms of what's going to happen, they're going to be interviewed, right, by the parole board. Will anything from that investigation impact the way you see anything?
So I don't think it will, and I'll tell you why. The parole board's decision is a risk analysis. We already have that risk analysis that's established in their prison files. It finds them at the lowest risk score, which is a 19. But that's the same risk score that Sirhan was at. It finds their California static risk assessment as low. That's the same low risk assessment that Sirhan had as well. So and it talks about their successful rehabilitation programs in prison and the educational degrees that they've received. The same with Sirhan while he was in prison. So I don't anticipate, quite candidly, any new information coming from this parole risk assessment, but the governor might use it in making his decision on commutation. Again, he's not bound by the facts and the law in the same way we are, the district attorney's office, when we deal with motions, resentencing motions or habeas petitions. He can rule on any reason for anything he wants to do, when it comes time for him deciding if he wants to commute the Menendez's sentence and release him today.
Nathan Hochman, I know you are super busy out there in Los Angeles, and we really appreciate your time. Thanks so much.
My pleasure. Thank you very much.
Coming up next, what does the family want?
I am here to ask the district attorney's office to take into account the full picture, the truth that was hidden for so long. Lyle and Eric deserve a chance to heal, and our family deserves a chance to heal with them.
This is the Court TV Podcast.
Lyle and Eric would continue to be victimized. They would be victims of a system that wouldn't hear them. And they would be victims of a culture that was not ready to listen. They would be mocked. They would be called cold-blooded killers, left to rot in jail and denied any hope of redemption. If Lyle and Eric's case were heard today, with the understanding we now have about abuse and PTSD, there is no doubt in my mind that their sentencing would have been very different.
Ana Maria Barral, she is the cousin of the Menendez brothers. She is the niece of Jose Menendez, the father who was murdered by her cousins. Interesting the way the family has been very, very vocal, which brings us to the next question in our investigation. And it's about the family. What does the family want? What do they want to see happen here? Obviously, a big part of the family is gone. They're the victims in this case. Let's bring in our guests joining us. Criminal defense attorney, former prosecutor in Los Angeles County, where all this is happening, and host of the Courtroom Confidential podcast, Josh Ritter, and forensic psychiatrist, author, and columnist, also in L.A., Dr. Carol Lieberman. Great to have you both here. I just want to read this first, this Menendez family statement, to get a clearer picture of what they're saying publicly. This is after the DA withdrew his resentencing support. Let's be clear, Eric and Lyle are not the same young boys they were more than 30 years ago. They have apologized for their actions, which were the results of Jose's sexual abuse and Kitty's enablement. They have apologized for the horrific actions they took. They have apologized to us, and they have demonstrated their atonement through actions that have helped improve countless lives, yet DA Hochman is effectively asking for them to publicly apologize to a checklist of actions they took in a state of shock and fear. DA Hochman broke his promise to listen to us, keep politics out of this review, and look at the full picture of the case. Josh Ritter, family wants him out. I think there's one holdout on Kitty's side, I believe, but it seems like the Menendez family, they want him out.
Yeah, it's a unique situation, though, because the family of the defendants is also the family of the victims. So when you ask the question, what does the family want? It's which side are they speaking for? This same family. And it seems like the family is overwhelmingly in support of the brothers, of the defendants in this case. And aside from one very vocal family member, none of them are in support of the idea that they should remain in prison any longer, which is a unique situation that you do not find very often in these types of situations where you're talking about pleas for leniency and mercy and resentencing. Usually it's, you're hearing from both sides, the victims' representatives who are saying how it's impacted their lives, and then also the defendants' representatives saying how they've done their time and they should be given a new opportunity. But here, that same group of people who represent both sides of this equation here are all in favor, like I said, aside from one notable exception, in them being released. And it really does come down to a question of they feel it's been enough time. They feel that 30 years is plenty of time for what they believe that they suffered through, that they should be given the opportunity to be released. And that is exactly what they're asking for. They're asking for their release. I think they would like to see it yesterday, if possible.
Dr. Carol Lieberman, these are, Josh points out, these are really unique dynamics when you talk about where this family is. Like, they're literally in the middle of it all.
Yes, the ones who are asking for their release are basically, saying, well, they killed my brother or my sister or my family member, but you should release them anyway. There were two brothers of Kitty who were against the release. And I think one of them is dead. That's Brian Anderson Sr. And there's still Milton Anderson. Now, he is denying that there was any abuse. He thinks that they killed them because of greed. He wants them to stay in jail, in prison. And, it's interesting because psychologically, I think he may not be ready to acknowledge that there was this abuse. Like, he may not want to admit to himself and to anybody else that his sister married a man who abused them in this way. And also wouldn't want to admit that his sister enabled them. There have been claims of her enabling them and also even some claims of her having abused them. So I think he doesn't want to believe any of that. So he's trying to stay in this safe place. On the other hand, it seems, there were lots of relatives at that hearing, at the press conference, and they were speaking, for their release. In particular, there was Joan Vandermullen, who's the sister of Kitty, and she was in her early 90s, and she was very impassioned, and she made the best impact of all. This elderly woman speaking so beautifully about what she believes. And in particular, she was saying that their actions were just two boys trying to survive the unspeakable cruelty. And she also said, I had no knowledge of the abuse. She wanted to make sure she was out of this. They were failed by their parents. She admitted that, and by the system and society. She said, and it's true, that society at that time wasn't ready to believe that boys could be raped.
Right.
If they were girls, it would have been much more easy.
What's interesting?
Much easier.
Is that the breakdown of Kitty's siblings is the same breakdown of the jury. The men, guilty, lock them up. The women, set them free. All right, our guests are staying with us. Up next, did the Menendez brothers lie?
The Court TV podcast will return.
I'm Vinnie Politan. We continue our investigation of the Menendez brothers. Now, they did kill their parents. They were convicted of double murder, and they were sentenced to life without parole. But now they're fighting for a chance at parole. Here's the story. On August 20th, 1989, the privileged world of Lyle and Eric Menendez shattered in a storm of gunfire and blood. Their parents, Jose and Kitty Menendez, were slaughtered in their Beverly Hills mansion, shot repeatedly with a 12-gauge shotgun. At first, the brothers played the role of grieving sons, but their extravagant spending after the murders raised suspicions. Soon the truth was unraveled. They had pulled the trigger. At trial, they didn't deny the killings, but claimed years of sexual, physical, and emotional abuse had driven them to murder or be murdered. The first jury's deadlocked, but the retrial sealed their fate. Life in prison, no parole. Now, decades later, the brothers are fighting for their freedom, looking to be resentenced and released on parole. But will the justice system see them as redeemable survivors or ruthless murderers who can never be free? So this resentencing hearing took a big turn when the new DA, Nathan Hochman, no longer supported the resentencing of the Menendez brothers like his predecessor did. There was an election. His predecessor obviously lost that election. And Nathan Hochman, take a listen one more time on his reasoning behind not supporting the resentencing of these double murderers.
The key issue of exhibiting insight, full insight into their crimes, and completely accepting responsibility for their actions. This is where the Menendezes, like Sirhan, also fall short. So if the Menendezes go ahead and want to, at any point, whether it's today, whether it's weeks from now, months from now, or years from now, finally and unequivocally express that they and acknowledge the lies that they have told and persisted in for over 30 years, then we will certainly evaluate the quality of that sincerity and decide whether or not it's real or fake, whether or not it's just designed to get out of jail, or whether or not they truly believe and acknowledge the full breadth of the crimes and lies they have told in deciding what to do at that point. And as importantly, the court will have to make that decision, and that decision is the court and the courts alone to make.
Okay, it's really because of the lies that the DA says, listen, they have lied and they have not taken responsibility. And that brings us to the next question in our investigation. We know the DA's answer to this question, but we're going to take a look at it. Did the Menendez brothers lie? Did they? Joining me, criminal defense attorney, former prosecutor in Los Angeles County, host of the Courtroom Confidential podcast, Josh Ritter, and former deputy public defender in LA County as well, Philip Dubé. Both of these great attorneys know this story, this case, the history very well. What I want to do, though, put this up on the screen because the DA, very detailed in the information that they've provided, including what they allege are the Menendez brothers' unacknowledged lies. And this first one, so huge. Eric and Lyle lied when they claimed that their parents were going to kill them, and they had to act in self-defense by murdering them first. Take a listen to DA Nathan Hochman talking about this lie.
The next iteration that ultimately came out at trial and just before trial was that both boys were molested by the father. But as you heard a moment ago, that wasn't a defense to the charges of first-degree murder with special circumstances. Because you had to add one more thing that the jury was now going to consider, is not just that they were sexually abused, but they were actually in actual fear of imminent harm, of their lives being taken by their parents the night of August 20th, 1989. So self-defense is the defense that they set forward at the trial.
Okay, Josh Ritter, but does the verdict answer this question that they lied about self-defense? That they lied about their parents were going to murder them, so they had to kill them first?
I mean, the jurors didn't buy it. The jurors didn't believe it. This is such an interesting point that he tries to make, though, about a lie, because it was a defense that they were making, and they were able to make it during the first trial, but not the second trial. And that's the idea of it wasn't so much self-defense, but imperfect self-defense. In other words, that they honestly believed they were in danger of their lives, but that belief was unreasonable. And that's the same kind of defense they tried to make in the second trial, but they weren't allowed to actually have that instruction. So instead, it was left with this idea that they believed that their parents were going to kill them, and none of the jurors bought that, and therefore, the rest is history. We know that they were convicted. But what Hochman's asking them to do here is to admit that their own subjective belief, though unreasonable, was a false belief, that they were lying when they said they even believed they were in fear. And that's so bizarre to me, because it asked them to take it a step farther. Rather than saying, yeah, we lied about the 911 call, yeah, we lied about some of the things after the murders and trying to cover it all up, but that we were lying about what we actually believed, even if that was mistaken. And that, to me, might be the most difficult obstacle of all, if anyone's actually expecting them to follow through on this challenge and admit these quote-unquote lies.
Philip Dubé, I want to get your take on it, but I want to read this first. This is from more from this list that they provided. This one, Eric and Lyle lied when they testified that they were so fearful of their parents that they stayed away from their home all day Saturday, even though they were impeached by the testimony of Grant Walker, the pool repairman, who said they were playing tennis and disrespecting their parents in front of him. So I think both of these things are sort of tied together. I mean, if they were in actual fear and believed they were going to be murdered, they took all those steps to buy the weapon and then were hanging out at the house. Don't hang at the house, you don't get murdered. Shouldn't they just admit their lies?
No way. And I'll tell you why. I think the prosecution is trying to conflate two separate statutes in California. One is the rules of court that deal with the appropriate sentence right after you're convicted. And there's a host of factors that the court can look to. Never mind the severity of the crime, the underlying crime facts, but also the remorsefulness of the defendants, whether or not they acknowledge any part in the crime, that type of thing. But that's not the posture of the post-conviction relief that they're seeking right now. The posture is a motion for re-sentencing. And the statute that has been put on the books by our legislature does not incorporate any term, condition, or requirement that you acknowledge your lies or that you even acknowledge that you committed the crime. I think what the DA's office is trying to do is impose and require conditions of resentencing that are outside of law. And I think to conflate that, it sends a wrong message to defense attorneys as to what their obligations are. And instead, we need to be hip and mindful of what current law is. And my reading of the new statute, 1172.1, simply does not require it. You merely look to whether or not they have been rehabilitated. You look at their traveling file in the prison to see if they have behaved, and you look to see if they have excelled academically, scholastically. Have they obtained any certifications?
But don't you want the support of the DA? You're going to fight the DA in a motion where it would be a much stronger case to get released if you have the support of the DA? Like if Gascon was in rubber stamping this thing, I think the judge would not hesitate for one moment. I think you have a much stronger case if, in fact, you get the support of the DA. And why not?
Not in this case. I'll tell you why. Because the DA is not applying the right law. The judge.
He's using the Sirhan precedent set by Gavin Newsom. Don't listen to the governor?
Parole. That's for purposes of parole. It's a separate bucket by which they're trying to seek the relief. But what is at issue now is resentencing under 1172.1. And if they try to argue that they are not contrite, they're not remorseful,
well, let me ask you another question then.
The judge is going to shut them down.
Let me ask you the more direct question. Philip Dubé, did they lie?
Of course, through their teeth.
Okay.
I have no doubt. Okay. I have no doubt. But that's not the standard.
That's not the standard, but that's a big part of our system of justice, though, isn't it, Josh Ritter? When people enter a plea and get a plea bargain, isn't that big mitigating factor that we all take into consideration acceptance of responsibility for what you did? Like, just admit it, come clean, don't play the system, admit what you did, and then we'll give you some benefit, which is what they're seeking here. I mean, they got the benefit already by not being on death row, but now they're looking for a benefit after. This is their second benefit that they're looking for.
And that's exactly why Hochman brought up the Sirhan case. Many people were going, why are we talking about a case decades earlier that involved a political assassination when we're comparing it to the Menendez brothers? But Hochman went back to that case because he had been, the parole board had recommended parole for Sirhan. They had said he's a low risk, a bunch of other factors, his age, everything else. They said, we think this man is eligible for parole. And Newsom rejected it based upon that idea of accepting full responsibility. So Hochman saying, okay, well, if this is a standard, if we're saying full acceptance of full responsibility is a standard here, then we don't really care about their risk assessment, whether or not they pose a risk if they're ever to be released. What we care about is this standard set by Newsom in the Sirhan case that talks about full acceptance of responsibility. We do not believe, as the DA's office, that has taken place here. And until we see that or demonstration of that, we're going to withdraw our support of resentencing. Remember, this was all brought by Gascon, who brought this motion to begin with. That's
the irony of all of this, that it was, it started the ball rolling from the DA's office. Philip Dubé, I'll let you wrap up this issue. 30 seconds.
Again, it goes back to conflating the law. What is going to be before the court is a motion or a petition to resentence. It is not a clemency petition. It is not a hearing before the parole board. And there is a very specific standard that will be before the court. And that is, would it be in the interest of justice to vacate the conviction, to maybe sentence them on a lesser included offense for time served, based on their lack of disciplinary history, based on all of their rehabilitation while in custody, and given their age at the time of the crime, they would otherwise be eligible for youthful offender parole. So what would be the harm? At a minimum, resentence them to life with parole so that at least the parole board can assess it and decide whether or not they are suitable candidates.
Philip Dubé, thank you so much. Josh Ritter, stick around. Still to come, are the Menendez brothers a risk to the community?
Is there an unreasonable risk of danger to the community by these particular people?
Now, back to the Court TV podcast.
They have been in prison for nearly 35 years. I believe that they have paid their debt to society.
That's George Gascon, the prior DA who wanted the Menendez brothers released, lost the election. New DA does not want them released. Let's take a listen to the new DA talking about the risk assessment from the files of the Menendez brothers.
As far as classification scores, they're all at the same level. A 19, which is considered the lowest level you can be at in the prison system. With respect to that California static risk assessment, they're all at the lowest level. Rules violations, you had 2. For Sirhan, the last one in 1972. You have 9 for Eric Menendez, the last in 2021, and 8 for Lyle Menendez, the last in 2024. They each have letters of support from prison officials, and the Menendezes have multiple letters from all living victim family members aside from one who recently passed. And they received those letters in support of their being released.
And that brings us to the next question in our investigation. And this takes into account if they are released or the basis for the release. Are the Menendez brothers a risk to the community? And that's a big concern when you release double murderers back into society. Still with me, former prosecutor in LA County, Josh Ritter, and joining me, forensic psychiatrist, author, columnist, also in Los Angeles, Dr. Carol Lieberman. Dr. Lieberman, let me start with you. Having lived the lives that they lived, right? Very different, you know, for the first couple decades, life of luxury, may have been sexually abused, but living Beverly Hills, all of that, then being locked up. Now they're grown men. What do you think their lives would be like if they were released? Would there be any danger? Would there be any reoffending by the Menendez brothers? What are your thoughts there?
Well, I don't think either one of them would kill somebody. However, I think that they do, or at least Lyle does, represent a danger. I think that whatever happens, there should be a difference made between Eric and Lyle because they are their contribution to what the crime was very different. Eric was sexually abused by his father and by Lyle. He told the psychiatrist, which was what ultimately led to their being charged. And he currently has a wife and his stepdaughter. He's had them for a while that he seems to be having a good relationship with. Lyle, on the other hand, he was the mastermind of the killing. He was the one who said that the father is going to kill them, you know, because when Eric told Lyle, that went against what the father had said. If you tell anybody, I'm going to kill you. So Lyle convinced, you know, Eric looked up to him. He was the bigger brother. And so it was Lyle who really masterminded the whole thing. I don't think Eric would have done it. Also, so I think Lyle is a sociopath. You know, we saw him behind the scenes where he was calling people and trying to get people to lie for him during their trials. And also he, you know, recently he had he's having an affair, so to speak, or he was having, I don't know if it's still going on, with a young woman from Britain, and she came to visit him, and he was found with contraband phones. So I think that the punishment, or when if they're released, that the time frame has to be different, because I think Lyle could go on and again not kill anybody, but do what sociopaths do, cheat them perhaps in financial dealings or something like that. So I think it should be different. I don't think it should be one size fits all.
Let me ask you, Josh, this is a fascinating approach. I haven't heard anyone else really dive into it the way that Dr. Lieberman has here. How about in the court, could you see a judge, or could you see Gavin Newsom, making it, because what we say, the Menendez brothers, we say the Menendez, it's like one person, but it's not. Two different people. Do you think our system of justice, whether it's the judge, the parole board, or the governor, would distinguish between Eric and Lyle?
Interesting to that point, Nathan Hochman made a point of saying that he wants to have them independently considered, that he's going to consider them as if this were independent requests for resentencing. They were tried separately. They had separate juries. They were treated separately throughout their entire criminal, experience with the criminal justice system. So it should be no different that they would be treated differently now. That all being said, I think for practical purposes, we all are doing exactly what you said, Vinnie. We're all considering them as like kind of one joint unit. And I would be shocked unless there was some very clear demonstration of behavioral differences since their time in prison. I would be shocked if a judge would come out with a different ruling on each of them, or certainly that the DA would treat them differently as far as proposing resentencing for one and not for the other. Now, and as far as clemency goes, I think the governor just considers them to be one unit. I don't think he's ever spoken about them any differently. But it is a question that I don't think many people are talking about. But that is certainly the way that the law is viewing it. And both of them are going to get an independent risk assessment that's going to be provided to the governor from the parole board.
Yeah, that would be some twist. We only have about 15 seconds left here, Dr. Lieberman, but psychologically, what would that do to the brothers if they were separated at this point and one got out and one was still in?
It would be fair. It would show them that there is a justice system. I think that really, they know what went on. And I think that would be a way to, plus we need to consider what impact their release is going to have on the rest of the world, besides like whether they would kill anyone or be sociopathic.
And all the other people trying to get out and the way the system treats them as well. We are out of time. Dr. Carol Lieberman, thank you so much. Josh Ritter, great to see you. This story, more than most, demonstrates the absolute need for cameras inside the courtroom. The Menendez brothers' first trial had cameras. The public saw the trial, and the public understood why the jury was deadlocked. The public was deadlocked. But no one saw the second trial other than the folks inside the courtroom. And the evidence that convicted them, no one saw it. And now many who don't know that evidence are calling for their release. I wonder if they would change their minds if they got to watch that second trial. I'm Vinnie Politan. We'll keep digging for answers as the investigation continues. There you have it. If you want to see more in-depth reporting on the latest true crime stories, you can see me every weeknight, 8 p.m. Eastern on Closing Arguments. Thank you so much for downloading. And as always, please don't forget to hug the kids.
This podcast is a production of Court TV. Go to CourtTV.com for more content, trials on demand, and to find out how to watch Court TV in your area.